Hello, my name is Irina Ozolina. I'm Russian attorney at law, Russian Eurasian patent and trademark attorney, senior partner of A.Zalesov and Partners. Today, I want to tell a little bit about the correlations between IP protection in Russia and unfair competition issues. On March the 4th, 2021, the Russian Supreme Court adopted a new Plenum, that is, guidelines on some issues arising from application by the courts of antitrust laws. Although the Plenum itself didn't change much for the IP practice in Russia, it's a good trigger to speak about the relevance of the unfair competition laws to the IP issues. The unfair competition is prohibited by the Paris Convention and by the law on competition protection. Actually, Article 4, Part 9 of the law on competition protection sets up general signs of unfair competition protection. Articles from 14.1 to 14.7 list the certain acts which are considered unfair competition by default, and Article 14.8 indicates that all other unfair competition behavior is prohibited, provided that the general signs of unfair competition are met. So the list is open. What are these general signs of unfair competition? First, the parties of the dispute should compete on the Russian market. Second, the challenged behavior should have an intent to get unreasonable advantages before the competitor. Third, the challenging behavior should infringe the law or business customs or be unfair, unreasonable, and unjust. And fourth, the challenged behavior should cause damages to the competitor or to create a threat of damages or to damage the reputation of the competitor. Four articles of the law on fair competition clearly relate to IP issues. Article 14.4 prohibits unfair trademark registration. Article 14.5 prohibits unfair competition by patent infringement, copyright, design, and know-how infringement. Article 14.6 prohibits creating confusion on the market. And here we have two types of creating confusion. First, trademark infringement, and second, parasitic attitude. Copying, imitating of the competitors' goods, corporate style, color combinations, packaging, provided that all these distinguishing elements are not registered as trademarks, that is the prohibition set up by the Part 2 of Article 14.6. In fact, to some extent, it's protection of unregistered trademarks in Russia. And Article 14.7 prohibits collecting, dissolving of commercial secrets and other secrets of the competitor. The new Plenum indicated once more that mere breach of law not always create unfair competition. That is, not every trademark infringement will be considered unfair competition if the general signs which are indicated in the definition are not met. And the Plenum also gave additional criteria. How can we understand the general signs of the competition, of the unfair competition, are present in the challenged behavior? First, the Plenum said that the challenged behavior can influence the state of competition on the market. Then it should differ from a normal behavior which should be anticipated from the fair marketplace, but who always have their own interests on the market. And third, all this intention to get unreasonable advantages from behavior on the market should be at the expense of the competitors. What are the ways for us to protect us from unfair competition? We have two ways to challenge the competitor's behavior. First, we can file an unfair competition action directly with administrative bodies responsible for competition protection, that is, antitrust bodies. It's either Federal Antitrust Service or its regional departments. Or we can apply it directly to the courts. Which way to choose? What are pros and cons of each of this way? First, the burden of proof. If you file directly with the antitrust bodies, it's them who collect necessary evidence to calculate the market share, to estimate the state of competition on the market. They have very strong powers to demand financial evidence from different market players. They have expertise and knowledge to prepare special opinions on the state of competition on the certain market and to calculate market share. If you go to the court directly, it's you who should collect all this evidence, who should invite specialists to prepare this kind of estimations and calculation. And we should remember that we do not have discovery in Russia. So from this point of view, it's much better to file first to antitrust bodies. Second, timing. Surprisingly, the courts are much faster rather than antitrust bodies. From one point of view, you'll get your result faster. From another, you have less time for collecting evidence. Third, the amount of instances. To some extent, it's also timing. Of course, if you file directly with the court, you skip the first administrative stage. If you file with the regional antitrust body, then the decision can be appealed optionally to the federal antitrust body, and then you go to the court of the first instance, the appeal instance, the first cassation. The first two can be skipped. From this point of view, of course, it's more time and cost saving to file directly with the court. And the last but not the least, the counterpart's awareness about your first motion. If you file a suit with the court, you should yourself notify the counterpart. If you file a motion about starting an unfair competition action with the antitrust bodies, first they estimate the circumstances you provided them. And if they agree that there are some signs of unfair competition, they start the case, and only after that they notify the counterpart. If they do not agree with you, they just notify you about it, and the counterpart never knows that you tried to initiate any action against them. What is also important to know, unfair competition actions on unfair trademark registration is considered by intellectual property court or by Federal Antitrust Service and then appealed to the intellectual property court. If you have positive decision, you should also file an invalidation action with the Russian Patent Office, attaching this decision of the Federal Anti-Monopoly Service or of IP Court. All other unfair competition actions are considered by regional courts if you file directly with the court, or by antitrust bodies, by regional department or by the Federal Antitrust Service. It's also worth to know that if Antitrust Service find out that there are signs of unfair competition, that the competitor's behavior is actually an unfair competition, then if they have reasons for that, they start an action on evolving administrative liability, on putting administrative liability on the counterpart. And in this case, the counterpart is exposed not only for reinstatement of damages to you, if there were damages, but also to a penalty which is paid to the state budget, which is quite high. This is very brief and short overview of the correlation between unfair competition actions and IP protection in Russia. We would like to tell you more about IP law and practice in Russia. Please subscribe to our channel. Thank you for listening, and goodbye.